Hello students, this is Dr. Rajmugli Amrishetty, practicing company secretary, corporate legal advisor and insolvency professional. Being an insolvency professional and also author of a book on lectures on insolvency and bankruptcy law, I am confident to properly discuss this topic and I am glad to be part of this knowledge sharing mission. In this part of the lesson, we will cover the detailed process involved in the insolvency resolution process, including fast track resolution process and liquidation, including voluntary liquidation for corporate persons, which is divided into 4 parts. That is, part 1, corporate insolvency resolution process. We are terming it as CIRP. Second one, corporate liquidation. Third one, voluntary liquidation, and fourth one, fast track resolution. Let us first deal with the corporate insolvency resolution process, CIRP. It is provided under part 2, chapter 2 and sections 6 to 32A and IBBI insolvency resolution process for corporate persons, regulations 2016. Now, let us understand stepwise process for CIRP. Firstly, who can file an application? CIRP can be initiated by financial creditor or operational creditor or corporate itself. Now, let us understand procedure for filing the application. Firstly, financial creditor can file an application under section 7 of IBC. When a bank or financial institution which provided the loan to corporate debtor and when there is a default of 1 crore or more, the financial creditor by itself or jointly with other financial creditors may make an application in form number 1 along with proof of documents to the NCLT having jurisdiction. After filing the application, the applicant shall dispatch forthwith a copy of the application filed with NCLT by registered post or speed post to the registered office of corporate debtor. Now, let us understand how an operational creditor can file an application. Operation creditor, here we mean a person who has supplied goods or services, and these processes dealt under section 8 and 9 of IBC. Firstly, operational creditor shall deliver to corporate debtor a demand notice in form 3 along with invoice in form 4 at registered office demanding the money to be paid to him. The demand notice to be sent either by hand or registered post or speed post with acknowledgement due, or by electronic mail service to whole time director or designated partner or KMP, that is key managerial person, and a copy of these documents to be filed with information utility. If no reply is received within 10 days, he may file an application with NCLT in form 5 along with documents required and shall dispatch forthwith copy to the registered office of the corporate debtor. Now, thirdly, the corporate debtor can also file, as we have discussed. These provisions are dealt under section 10 of the IBC. Corporate debtor may file an application in form 6 along with books of accounts and other documents. However, section 11 provides that corporate debtor himself cannot file the CIRP process in certain specified cases. Now, admission or rejection of the application. Once the application is received, the National Company Law Tribunal shall within 14 days of the receipt of the application ascertain the existence of default from the records of the IU or on the basis of other evidences furnished, either admit or reject the application. However, before rejecting the application, it shall give notice to the applicant to rectify the defect in his application within 7 days from the date of receipt of such notice. Now, appointment of the IRP. The financial creditor, while making an application, shall mention the name of the qualified resolution professional proposed to act as interim resolution professional at the time of submitting application. Similarly, corporate debtor may also mention the name of RP proposed to act as IRP. NCLT will appoint interim resolution professional if the name of the resolution professional is not mentioned in the application. In any case, the consent from resolution professional shall be obtained in Form 2 for appointment as an IRP. Now, insolvency commencement date means the date of admission of the application for initiating CIRP by NCLT under section 7, 9 or section 10 as the case may be, provided that where the interim resolution professional is not appointed in the order admitting application under section 7, 9 or 10, the insolvency commencement date shall be the date on which such interim resolution professional is appointed by the NCLT. Now, after filing an application is the process to withdraw the application. NCLT may permit withdrawal of the application on the request made by the applicant before admission or after admission based on the application made with the approval of 90% voting share of the committee of creditors. Once the application is admitted, there is a moratorium. Moratorium is granted once the application is admitted. This will be applicable till the end of the process. However, licenses, quota or registration shall not be suspended or cancelled for past dues during this moratorium period if the current dues are paid. Further, essential supplies must continue during the moratorium so long as current dues are paid. So, once the application is admitted and IRP is appointed, IRP takes the position and IRP starts the process. Initially, the RP is designated as interim resolution professional, IRP. The appointed IRP shall constitute the committee of creditors comprising of all the financial creditors of the corporate debtor. Minimum 51% of the voting share of financial creditors is required for a decision by the committee of creditors. But for certain key decisions of the committee of creditors, including appointment of the resolution professional, approval of the resolution plan and increasing the time limit for insolvency resolution process, the voting threshold is fixed at 66%. In case of consortium based lending, every financial creditor is eligible to be a part of the committee of creditors. The COC shall appoint resolution professional at the first meeting of COC. They may appoint interim resolution professional as RP or may appoint another RP. They may replace the RP at any time during the process of CIRP. During the pendency of CIRP, the RP would have to seek prior approval of the committee of creditors by convening a meeting prior to taking actions such as raising any interim finance, creation of any security interest, debiting any amounts and amendment of rights of creditors, etc. Now, RP has to prepare information memorandum. The RP is also mandated to prepare this information memorandum. This is similar to draft rehabilitation scheme under erstwhile laws. The resolution plan, primarily the objective of this resolution plan is to enable the debtor in resolving an insolvency situation and allow it as a going concern without resorting to liquidation, for which properly structured resolution plan would provide a strategy for repayment of debts after an evaluation of the debtor's worth. The interested parties may submit resolution plan based on the information available in the information memorandum. However, certain persons listed under section 29A, that is persons not eligible to be resolution applicants, cannot present resolution plan. Specifically, the resolution plan must provide for repayment of the debt of operational creditors in a manner such that it shall not be lesser than the amounts that would be due should the debtor be liquidated. Additionally, it should identify the manner of repayment of insolvency resolution costs, the implementation and supervision of the strategy, and should be in compliance with the law. If the terms, including the term of repayment under the resolution plan, are approved by the COC and subsequently by NCLT, the resolution plan would be implemented and the debtor may emerge from the debt crisis and with a fresh chance to conduct the business with less or no liabilities. Now, approval or rejection of resolution plan: once a person meets all the eligibility criteria and submit a resolution plan, in the event same is not approved by the committee of creditors or by the NCLT, the NCLT may direct the debtor to be liquidated. NCLT may also direct the liquidation of a CD in cases where it is in receipt of a complaint from a person affected by irregular implementation of the resolution plan. In those cases, if the resolution is not possible, the liquidation is ordered. However, all the CIRP process shall be completed within a maximum period of 330 days. Now, let us get into the liquidation process. In case if the resolution fails, now we enter into liquidation process. The liquidation process is provided under Part 2, Chapter 3, Sections 33 to 54 of IBC and IBBI Liquidation Process Regulations 2016. Circumstances when CD may be liquidated. Now, where the NCLT does not receive resolution plan within the stipulated period, this is one occasion. Second is when the NCLT reject the resolution plan recommended by the COC. Thirdly, when COC recommends liquidation with 66% of the majority. Fourthly, where the NCLT is of the opinion that resolution plan is contravened by the CD. In these circumstances, the liquidation is ordered. Then NCLT may pass an order to start liquidation process of such CD and issue a public announcement stating corporate debtor is in the process of liquidation and send the order to the authority with which the CD is registered. When an order to liquidate is passed, no suit or legal proceeding by or against the CD shall be maintained during the process of liquidation. Now, the appointment of liquidator. The question is whether the same RP who acted in the resolution process to be appointed as a liquidator or not. Where the NCLT passes an order to commence liquidation process, it may appoint IP who was dealing CIRP process as liquidator, subject to his consent to act as liquidator. All powers of the board, key managerial person, partner vest in the liquidator and all personnel of the corporator shall report to the liquidator. The following of the circumstances when RP may not be appointed as a liquidator. NCLT may by order shall replace the RP when resolution plan submitted by the RP was rejected for failure to meet the requirements. 2. IBBI recommends the replacement of RP by recording the reasons in writing, particularly when the RP fails to submit the consent letter. Now, after the liquidator is appointed, what are the powers of the liquidator? Subject to the direction of adjudicating authority, the liquidator shall have the following powers. Number 1, he shall verify claims of all the creditors. 2, he shall take custody of all assets, properties and actionable claims of the corporate debtor. 3, he should evaluate the assets and property of the corporate debtor and prepare a report. Fourthly, he shall take such measures required to protect and preserve the assets of the corporate debtor. He shall carry on the business of the corporate debtor for beneficial liquidation. Sixth, he shall sell the movable, immovable property and actionable claim by public auction or private contract, or sell the same in parcels, but shall not sell to any person who is not eligible to be a resolution applicant. Seventh one, he shall draw, accept or endorse negotiable instruments on behalf of the CD. Eighth, he shall collect money due and payable from contributory or his estate. Ninth one, obtain any professional assistance from any person. 10th one, he shall invite, settle the claims of creditors and claimants. The 11th one, he shall investigate financial affairs of the corporate debtor to determine undervalued or preferential transactions, and report the progress of liquidation process from time to time. Now, liquidator has the power to consult any stakeholder entitled for distribution, provided such consultation shall not be binding the liquidator. He shall preserve a physical as well as electronic copy of the reports and minutes for a period of 8 years after dissolution of the CD. Now, liquidation asset. Liquidator shall form an estate of assets, which is called as liquidation estate in relation to CD, which the liquidator shall hold for fiduciary capacity for the benefit of all creditors. Liquidation asset shall include all the assets owned by the corporate debtor as per balance sheet or information utility or in the custody of other authorities as may be specified by IBBI, including shares in subsidiary companies. Which type of assets shall constitute liquidation asset and which assets should not form part of the liquidation assets are detailed in IBC. Valuation of assets. Where valuation has been conducted for the purposes of insolvency or fast track insolvency, liquidator may use such valuation. If not, within 7 days of liquidation commencement date, appoint 2 registered valuers to determine the realizable value of the assets or business. They shall independently submit the estimates of realizable value of assets or business as the case may be, computed in accordance with the company's registered valuers and valuation rules 2017 after physical verification of the assets or business. The average of the 2 such estimates is the value of the asset or liquidation estate of the corporate debtor. Now, powers of the liquidator to access information of the CD. Liquidator shall have power to access any information, systems for the purpose of admission, proof of claims and identification of liquidation assets relating to CD. Creditor may require liquidator to provide financial information which shall be provided within 7 days of receipt of the such request. Consolidation of the claims. Liquidator shall call and finalize the claims of creditors within 30 days from the date of commencement of liquidation. A creditor may withdraw his claim within 14 days of submission of his claims. Verification of claims. The liquidator shall verify the claims after seeking required information from the creditors. Liquidator may either admit or reject the claims after verification in whole or in part and shall record reasons in writing in case of rejection. He should use the best judgment while accepting or rejecting the claims. Communicate his decision to the creditors and CD within 7 days of such admission or rejection. Creditor may appeal to NCLT within 14 days of receipt of such a decision. Now, transaction to be dealt by the liquidator. The liquidator shall investigate and deal with the preferential claims, undervalued claims, extortionate transactions, disclaimer of onerous transactions effectively for proper and equitable liquidation of the company. Now, distribution of assets. order of the priority, which is called waterfall mechanism, is contained under section 53. Under this waterfall mechanism, the priorities for payment have been changed when compared to erstwhile laws. The priority of the payments is as follows. Number 1, insolvency resolution cost and liquidation cost, that has to be paid in full. Secondly, the debts shall rank equally. That is, first, workman dues of 24 months preceding liquidation of the corporate debtor. 2, debts owed to secured creditors who have relinquished their security. Wages owed to employees of preceding 12 months. Financial debts owed to unsecured creditors. The following dues shall rank equally, that is, amount due to governments, that is 2 years preceding liquidation commencement date. 2, debts owed to secured creditors for amount unpaid after realizing security. Any remaining debts and dues. Preference shareholders, if any. Equity shareholders or partners, as the case may be. Now, dissolution of the CD. Once the amounts are paid, now the question is how it is dissolved. Where the assets of the CD have been completely liquidated, the liquidator shall make application to NCLT for dissolution. Upon such order, copy shall be forwarded to the authority with whom CD is registered within 7 days of such order. Now, liquidator to complete the liquidation process within a period of 2 years, failing which he shall make an application to NCLT along with report explaining why liquidation could not be completed and additional time required to complete the liquidation. Now, let us come to third part of it. Third part of it is voluntary liquidation. Though this voluntary liquidation process is not mandated under the IBC, but it is contained here for the sake of ease of doing business. As per section 59 of IBC, a corporate person who intends to liquidate itself voluntarily and has not committed any default may initiate voluntary liquidation proceedings. The conditions to be fulfilled before going for voluntary declaration are: number 1, a declaration from majority of the directors of the company verified by an affidavit stating that they have made a full inquiry into the affairs of the company and they have formed an opinion that either the company has no debt or that it will be able to pay its debts in full from the proceeds of the assets to be sold in the voluntary liquidation, and that the company is not being liquidated to defraud any person. 2, within 4 weeks of such declaration, a special resolution of the members of the company in general meeting to be passed requires the company to be liquidation and appointing the insolvency professional to act as the liquidator. Third one, in case company owes any debt to any person, creditors representing 2/3 in value of the debt of the company shall approve the resolution passed by the shareholders within 7 days of such resolution. Now, fourth one, within 7 days of such resolution, the company shall inform the concerned authority where the corporate debtor is registered and to the IBBI. The process laid down under section 35 to 53 shall be followed for such voluntary liquidation. Section 35 to 53 deals with the liquidation process. Now, sixth one, where the affairs of the corporate person have been completely wound up and its assets completely liquidated, the liquidator shall make an application to NCLT for dissolution of such corporate person. The NCLT shall an application pass an order that the CD shall be dissolved from the date of that order and the CD shall be dissolved accordingly. Within 14 days from such order, a copy of such order shall be filed with the authority where the CD is registered. This is a simple process is laid down under IBC for voluntary liquidation of the companies. Now, Students, let us get to the fourth one, that is fast track resolution process, which the provisions of which are contained under part 2, chapter 4 and sections 55 to 58. As the regular CIRP may take some time, that is 330 days, fast track CIRP is contemplated and provided in the IBC under section 55 to 58. Now, in respect of certain CDs, as per notification dated 14th June 2017, the following are the conditions laid down. A small company as defined under section 2 subsection 85 of the Companies Act may opt for fast track CIRP. 2. Similarly, a startup other than partnership firm may also opt for fast track CIRP. 3. The unlisted company with total assets are reported in the financial statement of the immediately preceding financial year not exceeding 1 crore may also opt for fast track CIRP. Now, time period for completion of fast track CIRP. Fast track CIRP shall be completed within a period of 90 days from the insolvency commencement date, as against the 330 days contemplated in the regular CIRP. 2. The RP shall file an application to NCLT to extend the period, that is beyond 90 days under the fast track CIRP process, if instructed by the COC and supported by a vote of 75% of the voting share. If the NCLT is satisfied that the subject matter of the case is such that the fast track CIRP cannot be completed within a period of 90 days, it may extend, but not exceeding 45 days. So, 90 plus 45 days is the maximum date within which the fast track CIRP has to be completed, provided that any extension of the fast track CIRP under this section shall not be granted more than once. An application for fast track CIRP may be filed by the creditor or CD himself along with the proof of existence of default as evidenced by the records available with an IU or such other means as may be specified by the board, and such other information as may be specified by the board to establish that CD is eligible for fast track CIRP. Now, applicability of the regular CIRP process for this fast track CIRP regarding the appointment of the IRP, RP, etc., the regular process prescribed under the CIRP will be applicable in this, for the fast track CIRP as well. Hi students, now we have discussed about the 4 important processes involved under part 2, which is applicable to companies and limited liability partnerships, which is the main body of the IBC. Now, first process we have discussed is that corporate insolvency resolution process, which we mean in case if the company becomes insolvent, as contemplated under the IBC, first step is to set right the difficulties and see that it is resolved and become debt free company. In case if it cannot become the debt free company, then ultimately the process involved is liquidation of the company. We have also discussed what the liquidation process and how it has to go. Further, we have also discussed in the last step fast track insolvency resolution process. In some cases, like you have seen that small company or startup company or a company whose paid up capital or the turnover is less than 1 crore, fast track resolution is contemplated, which is a very good sign. And other important thing we have also discussed is voluntary liquidation. As a matter of fact, voluntary liquidation is not the part of the insolvency and bankruptcy code. However, it is included in this code to make it as a comprehensive one, and as a part of ease of doing business. The voluntary liquidation part, section 59 precisely says about the steps to be taken to liquidate the company. The entire process contemplated for voluntary liquidation is only 2 years. Within 2 years, the company ought to be liquidated, as against the earlier World Bank estimate of 4.5 to 5 years for liquidation of a company. Thank you, students. You have learned now the important processes involved under the IBC.